Sherry Tucker. I'm an estate planning lawyer and elder lawyer. And the reason I come in is in elder law, we deal with people who have disabilities, so people who are senior citizens and people with disabilities have many of the same issues and challenges and questions. So what I'd like to do is we're going to talk a little bit and start on guardianship and conservatorship. And then I want to talk to you about an alternative with powers of attorney. And we'll also cover some special needs trust, okay? So I work with all this, different aspects of the whole gamut, guardianship and conservatorship. It occurs in probate court. It's very specific. There are very specific laws that come into play when you're talking about guardianship and conservatorship. So I always start with, having the parents think about the goal, as well as the adult with the disability. So planning is bringing the future into the present so you can do something about it now. And it's very important to think about your goal and what is the plan. Because too often I have gotten clients when there has not been planning, and then we are having to do what's called crisis planning. And it's just because things haven't been put into place beforehand. So when I'm talking to you as the parent and you with the disability as an adult, let's think about what is the goal. What do you, parent, want for your adult child? Do you want the adult child, the child aging to this adulthood, to have some autonomy? Do you want financial security for your child? Do you want your child to be involved in a set community? Do you want your child to stay home and live with you? Do you want to maintain some form of control as the child is aging into adulthood and then later? So we're talking about degrees of control and degrees of autonomy. And it's very important as we think about this because of what the laws are in place for guardianship and conservatorship. So when we talk about guardianship, we have full, limited, and standby. What does that mean? You've got so many things to look at, and many of your adults, children are past the age of the high school. But too often, you have the child in high school at 17, and suddenly you have their IEP teacher going, you've got to go get guardianship before they're 18 and take over everything. Well, when the high school teachers are doing that, what they really are saying to you is, when they turn 18, I'm going to have a bigger headache because now I'm dealing with a legal adult age. And you, the parent, if you don't have anything in place, we're not going to be able to work very well with you, the parent, when this child is 18. So we have this big push in the education system to have parents gain full control over their child aging into adulthood. Well, when you're looking at the guardianship in the past, guardianship, and even somewhat now, Guardianship takes rights away from the adult who has a guardian. The guardian makes all the decisions, and it was in the past, just within the last 2 years, they lost the right to vote. They even lost the right to marry. So they lost basic human rights that we take for granted, okay? Well, now we have different laws in place. And it says, do you want full or do you want limited, where you're making some decisions for your child, okay? Or do you want standby, that when there can't be any decisions made, I come in to play? We see this not only with the adult aging into with the disability, but we also see it with senior citizens who are heading towards incapacity. So that's why we have full, limited, and standby. So in guardianship today, your adult child, which we really need to work on a different term, can petition the court. If you have guardianship, they can petition the court for the right to marry. They can petition the court and they can say, I understand voting and I want to be able to cast my vote. So there is some new laws in place that is the least alternative environment, right? So what we're seeing now is a move away from parents having full, total control over the adult with the disability and more autonomy. So that's a move that we're seeing legally in statutes and in the court system, right? So guardianship is over the person. And so think about that for a minute. Guardianship is over the person. Okay. So you're thinking about, what do you want to accomplish as a guardian? Now, conservatorship is over the money, over the finances. So let's say you have, does anybody have one of their adult children in the home working? Anybody? Yeah, you can put it in the chat. McKinney. Jasmine, does Denaz work? Linda, does Jonathan work?
John works. He lives with us and he works.
Okay. Karen, does Mickey work? Not sure. Oh, she doesn't get paid, so she's on Social Security. Okay. All right. So conservatorship is over the finances. Now, I mean, we can. I think there's no argument that your adult child can work, earn money, but most likely does not have the concept of money. Would you say that's correct? Yeah, McKinney. You see, so when they're like, when they earn a paycheck, in their mind, maybe they think they can go buy a car. So, the conservatorship, I don't think we have any argument about taking full control over that money, letting them earn money and then helping them be able to wisely spend that money, because there isn't the concept there. Okay, so it's more of the guiding process of the conservatorship. So when we're thinking about what do you want? How much autonomy? The real question then, it really is about guardianship. Do I want full guardianship where I control everything? And it's just really difficult as a parent when you're thinking about this, because you've been the guardian until 18. And now you have the adult with a disability, and you're going, well, do I stay the full guardian, the full controller over the adult? The one thing about guardianship is that the courts look and they'll say, well, is the parent really the best guardian? And usually the parent will be considered the guardian. If not, the court has to be told why that parent should not be a guardian. Much like a divorce process, or if you have a senior who's incapacitated, the whole question is who's going to best serve what is then becomes the ward. Because every year as a guardian, you are giving a report to the court. It's the same as if you had conservatorship. If you had legal conservatorship over your adult child, right? If it's in the court, you're appointed the guardian, you're appointed the conservator. Every year, you have to give the court a report on the plan and a report on the finances. So it's you're just looking at a lot of paperwork every year that you're going to have to do, okay? And, often it's interesting that, let's say you're the guardian, a legal guardian. You've gone to court, the court's appointed you guardian. I have had people come to me and say, well, I'm making a will and I'm going to appoint blah, blah, blah as the guardian over my brother with a disability, okay? And I'm the guardian now, but I need to appoint someone as the guardian. Well, that's fine, but that necessarily might not be what happens. So just like in guardianship, a child who is 14 years of age can have input into who is going to be the guardian. And it is the court who decides who is going to be the guardian. You can have it in your will. You can have it in a power of attorney. You can have it anywhere else written down, but it is the court who is going to decide who the guardian is. And there is a right for input. So I just want everyone to think about that. When you're thinking about the legal guardianship through the probate court system, okay? So the important thing is that the guardian has immediate custody, and it has to be least restrictive. If the court thinks that you're going to dictate and take control over the entire life, there's going to be a pause, okay? Because that was back in the days when people with disabilities did not have that much many rights. So they want least restrictive. They want who is going to provide support, care, health, maintenance, and education. And that role, the guardianship role, takes precedence over the family role of mother, father. Okay, and guardianship will end at any power of attorney. Okay, so that's some, just think about the guardianship on the legal aspect. If you did the legal pursuit of guardianship and conservatorship. So conservatorship, you're over the finances. You have to make a yearly report to the court. You need to make investments on behalf of the ward, and you also make disbursements of annual income. So what are we talking about on challenges? Okay, well, a guardian, you have to protect the ward, but you also must provide autonomy. And it's a long haul appointment. So if you do not outlive the ward, you have to think about the person who is going to succeed you that the court will approve. They also want to make sure that the guardian maintains what's called the dignity of the person. So with the children who have the disability, they are aging into adulthood, they are living longer, and we have a least restrictive alternative than guardianship. So I've tried to talk to you about the legal part of it, and that means going to court, paying an attorney, filling out documents, and getting appointed. Well, in today's world, as your child is growing older, what is the least restrictive alternative than guardianship? And there are choices. We have one of the main ones, and McKinney, you can chime in here, is for a team care, advocacy group, care management team that gets put together to help with the decisions for the child with a disability. And I know I have just completed a third-party special needs trust, and in it are provisions for a trust protector, a care manager, and the care management team, and how that gets put into place, and what their duties are and their responsibilities. So it's very important when we're doing things like this, and you're thinking about, okay, I don't want the legal guardianship through probate court, or I want a limited, but I want this care management team aspect. It's really something that we're moving towards, that we're trying to educate people about and get parents to think about, because as your child lives longer, then we would like to have in place people surrounding the adult and helping them through life. McKinney, do you want to talk a little bit about maybe, a little bit about what the care management team might look like?
So what you would probably do if you decided to go the road of care management team is you would sit down and decide amongst you and your adult child, who are the people that are influencers, my word, influencers in that particular child's life. Is it someone from a religious institution? Is it someone that has been known this child growing up from a teacher that has known this child all of their lives? Is it an aunt or an uncle that is maybe younger than the parent that can be more involved? Is it a neighbor? But people that you can surround this child with, sort of like this circle of people who are there and will be there, that this child will not only help this child make good decisions, but will be there that this child can like call when they need something, not just physical like money, but things that they would need psychologically, like, I got a boyfriend, I need to have somebody talk to me about this kind of thing beyond just my parents. But the care team system sets up these people, and you set them up where you would have meetings and you would have agendas, and you would go through just like any other kind of team in your job. Or even, I think about when my sister-in-law was in the hospital, we sat down with the care team and they talked about all of the things that were going on. You would want to have a medical person involved in it as well. So the care management team is one that could possibly work for some families.
And when I'm working with the special needs trust, and I also look at what are the powers of attorney that are needed. So when we have powers of attorney, and I see Jasmine has asked a question, and just a minute, Jasmine, and I will get to your question here. So when we're looking at legal guardianship, legal conservatorship, is that the best route for the autonomy of the child with the disability? And we're looking more and more at the least restrictive alternative, which is the care management team using special needs trust and using powers of attorney. Now, here's the caveat. And parents have a hard time grasping and working with this concept because they know their child. And they say, well, my child's IQ is, and then you fill in the blank, right? And my child can't possibly understand what a power of attorney is. However, it is really an attorney who sits down and determines legal capacity, not IQ capacity, but legal capacity. And there's certain ways that we go about sitting down with that adult, asking questions, and also looking at what the parent's information is with the IQ. I've had parents also take their adult and have a doctor look at the adult and write a determination that he or she is able to sign a power of attorney. So when we're looking at that on the powers of attorney, the big one is health, having someone with overseeing medical records and help with those health issues. Financial power of attorney, it's interesting because they do know that they need help with money. And so we go through, and there are adults with Down syndrome that have sat down and we've done health powers of attorney and financial powers of attorney. And in each of those, there is a determination, there is a who would you like to be guardian, who would you like to be conservator if that had to be decided. The one document that I cannot do with adults with a severe disability is the Advanced Healthcare Directive, also called the Living Will. I cannot do that document because there is no concept about death. I have experience in this years and years and years, And that document I can't do because there's just no understanding, no concept of the death process and the end of life process. So that's why the health care power of attorney becomes very important, because if you if you do outlive the child with the disability, you need to have something in place to help make that end of life decision, because they will be the adult age. So I really would like for parents to think about the process of powers of attorney as the least restrictive, as an alternative than going to court for a full guardianship and conservatorship. Why? Well, we also would like to look at the special needs trust. And I'll get to Jasmine's question. She said, if we already have a special needs trust set up and guardianship and we move out of state, do you need to make changes? Yes, you do. Guardianship is determined by the court where you have residence, and you have to take that guardianship and go to the court and file it and go through that process in another state. Special needs trust, it just depends. So I'm going to talk about the purpose of a special needs trust versus ABLE accounts, all right? So the purpose of a special needs trust is always about the quality of life and providing a quality of life. It will cover personal needs outside the scope of government benefits. It covers medical that is not covered by government benefits, and it gives a quality of life and personal expense distributions, like traveling to see family, clothing, social interactions, and tickets to the theater, philharmonic, plays, tickets to the movies. It can pay for expenses, but it can never be cash given directly to a beneficiary. So let's say you have the determination of a disability by the Social Security office before the age of 26. So this fits your children aging into adulthood, okay? They could qualify for an ABLE account with the state of Missouri. Does it have to be an ABLE account from Missouri? You can actually state shop for the best. But in Missouri, you have to be a Missouri resident. Some states, you do not have to be a resident, and you can shop and get their ABLE account. Well, people will say, okay, have an ABLE account, build it up, you can put in, money in that. Well, people don't understand is that ABLE account is a payback to the state. So what you really want to do is put their SSI money into the ABLE and have a special needs trust that you put other money into. In fact, as a parent, you want a special needs trust, because if you do not have a special needs trust and you die and you leave something directly to your child, you will disqualify him or her from government benefits. I cannot stress that enough. If you do not have a special needs trust set up and you leave retirement funds, you leave life insurance, you leave a house, you leave whatever you leave, and you do not leave it to that child's third-party trust, you can him or her to lose their government benefits. I mean, I have seen it. We've had to do different things because, you know, grandma did not think about changing her will to put everything to a trust, you know, for grandson, granddaughter. And then we're having to do extra things because it did not flow into a trust. So a special needs trust, it becomes really, really your child's best friend financially, for financial security as he or she matures, and as you grow older, you just cannot really truly be without one. You can set up the ABLE account. They can have both going at the same time. The ABLE account is good to have because it's tax-free. It's an investment account. People are like, well, what if they get too much? Your child can have an ABLE and an S&T. It can grow to over $400,000 before they lose benefits. It's fine. All right. And then once they go down again, they requalify for government benefits and it builds back up. So you're thinking about playing a financial game with how to provide this quality of life. Also, Jasmine, on the special needs trust, thinking about, well, what changes do I need? Right now, I have a client and another attorney drew up the trust. And it's an older special needs trust, and they made it irrevocable. A third party, you don't have to say it's irrevocable right off. You can say it's revocable until someone donates about, $10,000 or $15,000 or more, other than me, the parent, and it'll become irrevocable. Okay. Well, if it's irrevocable and you have no what's called trust protector language in it, you have no way to decant it. As taxes change, as estate planning laws change, you are kind of stuck with this trust that you can't decant, you can't make changes. And then it's a matter of having to go to court and getting kind of breaking the trust to be able to decant, to be able to fix it. So you want some language in there that you can have what's called a trust protector. And that means a person not related to any of the family who can step in, and they tend to be like a CPA or some type of fiduciary, and they can come in and say, our trustees died. We need another trustee. I will appoint this trustee. We have some new language that we need to look at. We have some different fundings that we need to move around. So a trust protector protects, just like it says, protects the trust and helps it stay flexible even though it's irrevocable. So there's different language that we need to make sure that we put in there. And then for mine, I do put in advocacy. I have a whole article that deals with who is going to be the child's advocate, and then who is going to be the child's care manager, and then what does the care manager team look like? So all of that language is language that we are saying is needed now because our children are aging into adulthood and living longer. So the trust really, truly needs to be a document that can last for a very, very long time and be able to have someone look at it and work with language and move investments around so that the child does have the most benefit and quality of life, and think beyond, the parents' life. In times past, we didn't have to really think about that. We had a special needs trust, and it more helped the parents provide a quality of life. And the reality is now you need the special needs trust so that when the parent who is now no longer outliving the adult with the disability, having peace of mind so that the child, this adult, has a quality of life that extends beyond the parent's lifetime and still maintains government benefits. So there's a lot that's going on right now with the people with disabilities aging into adulthood, and how do we help parents really think about the less autonomy thought process, because it's just come to a point now as we see the life expand longer, that the parents, when they did have the full guardianship, they had full control, and the child wasn't outliving the parent. But now we're seeing the outliving of the parent with the disability, and having to really think about making adjustments to provide that quality of life.
This care management team you're talking about, do you actually implement that in the trust, or is basically like a set of guidelines that are, mention it in there and then refer to this care management team, or how do you?
I name an advocate, so I sit down, and right now I'm working with a mom, and I said, who do you want to be the advocate? And who do you want to be a care manager? And we define, like, we want one social worker, one, we put at least 3 people in there and say, here they are. We want at least one, and one of this, okay? Mm-hmm. And then the advocate and the care manager team thinks, who else do we need? Like if with Down syndrome, you may want someone directly involved with the Down Syndrome Association who has good ties, who has good connections, who's involved, to be on that care management team because they understand Down syndrome.
Right.
So you put the roles, but then you say, okay, care management team, you'll fill out the gaps. If he's really into, a certain hobby or a certain job, there's a strong interest, then they may want to reach out, to somebody who also has an interest like that. But what you want are people who know your son or daughter and who understand the strengths and what they like, and they can come in. So I didn't get to answer. Okay, I see Karen has a question too. She's on SSI. When you have a third-party trust, there is not a limit. The third-party trust is not the same as a first party. So when you have life insurance money, Karen, you name her third-party trust. Okay, and some of you are, what's the difference? Well, the third party parent or a grandparent sets up for the child. A first party is the child sets up for self. When you would have that is say you have a child who, or an adult who goes and buys a Powerball ticket and wins, and they have government benefits, and now they have to set up a first party trust, and it will affect the benefits if they misuse their trust money. So now we're talking about having a trustee who makes sure that they don't misuse the trust money. And I had this, I had a client who had a trust, had everything was set up, and then the mother died. And the trust wasn't named. And then, but named the son as personal representative. So there wasn't mental incapacity, but in a way there was. But he then decided to take that money, and because he took the money directly out of the bank and did not put it in the trust, he lost his SSI. Mm-hmm. So that's some, unfortunate, that's some things that can happen. So the third party you all are setting up, and it's fine. So you can put into that trust. The big question is, well, who's the trustee, right? It can't be any of your children. Okay. It can't be any other children. It can't be a beneficiary you can't have as a trustee over Jonathan. So who's going to be a trustee? And we get into the problem of how much money is there. Okay. How much money is in there, because like banks, they usually want $1 million. And you're sitting there going, who's going to be the trustee of the trust? And many, think, well, we can set up, we can put it in a bank account. And that's true. And that's why I said, is it going to be revocable or irrevocable? You can have it as revocable, but many parents don't know that. You can have it as revocable, and you can even put in there that it becomes irrevocable if it reaches a certain dollar limit, or if somebody were to leave, let's say his grandparent left $50,000 to him, or a life insurance policy that was worth $100,000 to his trust, then it becomes irrevocable. Now you have to think, well, who's going to be the trustee of the trust? And those are some of the questions. There's some CPAs who will be trustees. There are fiduciaries, but usually when it's in a certain dollar amount, banks and stuff, they want the big money. So then you're having to think about who's going to be that trustee. Not Medicare, Medicaid. Medicare and Medicaid are different things. And she can still qualify, but you name her third party trust. The other issue that you need to consider on a special needs trust is your retirement benefits. Your retirement benefits, the Security Act of 2019 changed last year the stretching of retirement benefits. So the exception is a child with a disability, but you must have special language for your retirement benefits, and making it what's called, this gets a little complex, an accumulation trust. Okay, so that's very important. You must have language in there that allows your retirement benefit to be stretched for the child with a disability. Otherwise, they have to spend it down 5 years, and that's a big tax burden. So you have to make sure you have that special language. Yeah, that's new. I didn't know if you knew that, McKinney,
Yeah.
about the Security Act of 2019.
I just learned about that recently.
Yeah, big change. So I would say with people with the special needs trust, if you know of anyone who has that special needs trust already,
Mhm.
that needs to be revised to get that language in there so that it meets the Security Act of 2019.
Okay.
Yeah, another reason why you want a trust protector in there and decanting language so that you can fix things as they come up like that. Medicare is not dollar related, Karen, so she would be okay.
Yeah.
It's Medicaid that is dollar related.
Mm-hmm.
With a third party, it would not affect either Medicare or Medicaid. It's really important. Like if you have something that is a yearly or something special for the family that you do specifically, at least put in there. And by the way, every year, care manager team in the care plan is that we always, for the birthday, would go to, and wherever, Disney World, Universal Studios, whatever, if you have this ritual, and it's a very important ritual to your child, is that you make sure it gets included as part of that plan. It's like I tell parents when they're setting up a guardianship and a will, because that's another thing that goes through probate, is when you have a minor and you name a guardian, I always encourage my parents to please write a letter to your child, write a letter to who you choose as a guardian, talking about your family experiences and what is important to the family, to Jonathan, things that Jonathan likes to do that really makes him happy, that he's good at. And when you have that information, you are giving people that information to really help Jonathan or help Mickey have a good quality of life beyond you. And it's just very important to take that step and put that information down.
Yeah.
Putting everything together is really important, and having those documents, having your binders. And I that letter of intent is important. It's not legal, it's not binding, but it's the heart. Whereas the special needs trust is the legal. Okay.
Mm-hmm. Mm-hmm.
McKinney, thank you so much for having me.
Thank you so much. You all have a great evening.